Proposed amendments to the 1997 Rules of Civil Procedure. Rule number 6. Kinds of Pleadings. Section 1. Pleadings defined. Pleadings are the written statements of the respective claims and defenses of the parties submitted to the court for appropriate judgment. Section 2. Pleadings allowed. The claims of a party are asserted in a complaint, counterclaim, cross-claim, third, fourth, etc. party complaint, or complaint in intervention. The defenses of a party are alleged in the answer to the pleading asserting a claim against him or her. An answer may be responded to by reply only if the defending party attaches an actionable document to the answer. Section 3. Complaint. The complaint is the pleading alleging the plaintiff's or claiming parties' cause or causes of action. The names and residences of the plaintiff and defendant must be stated in the complaint. Section 4. Answer. An answer is a pleading in which a defending party sets forth his or her defenses. Section 5. Defenses. Defenses may either be negative or affirmative. A negative defense is the specific denial of the material fact or facts alleged in the pleading of the claimant essential to his or her cause or causes of action. B. An affirmative defense is an allegation of a new matter which, while hypothetically admitting the material allegations in the pleading of the claimant, would nevertheless prevent or bar recovery by him or her. The affirmative defenses include fraud, statute of limitations, release, payment, illegality, statute of frauds, estoppel, former recovery, discharge in bankruptcy, and any other matter by way of confession and avoidance. Affirmative defenses may also include grounds for the dismissal of a complaint, specifically that the court has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, or that the action is barred by a prior judgment. Section 6. Counterclaim. A counterclaim is any claim which a defending party may have against an opposing party. Section 7. Compulsory counterclaim. A compulsory counterclaim is one which, being cognizable by the regular courts of justice, arises out of or is connected with the transaction or occurrence constituting the subject matter of the opposing party's claim and does not require for its adjudication the presence of third parties of whom the court cannot acquire jurisdiction. Such a counterclaim must be within the jurisdiction of the court, both as to the amount and the nature thereof, except that in an original action before the original trial court, the counterclaim may be considered compulsory regardless of the amount. A compulsory counterclaim not raised in the same action is barred, unless otherwise allowed by these rules. Section 8. Cross-claim. A cross-claim is any claim by one party against a co-party arising out of the transaction or occurrence that is the subject matter either of the original action or of a counterclaim therein. Such cross-claim may cover all or part of the original claim. Section 9. Counterclaims and cross-claims. A counterclaim may be asserted against an original counterclaimant. A cross-claim may also be filed against an original cross-claimant. Section 10. Reply. All new matters alleged in the answer are deemed controverted. If the plaintiff wishes to interpose any claims arising out of the new matters so alleged, such claims shall be set forth in an amended or supplemental complaint. However, the plaintiff may file a reply only if the defending party attaches an actionable document to his or her answer. A reply is a pleading, the office or function of which is to deny or allege facts in denial or avoidance of new matters alleged in or relating to said actionable document. In the event of an actionable document attached to the reply, the defendant may file a rejoinder if the same is based solely on an actionable document. Section 11. Third, fourth, etc. party complaint. A third, fourth, etc. party complaint is a claim that a defending party may, with leave of court, file against a person not a party to the action, called the third or fourth or more party defendant, for contribution, indemnity, subrogation, or any other relief in respect of his or her opponent's claim. The third, fourth, etc. party complaint shall be denied admission, and the court shall require the defendant to institute a separate action, where a. the third, fourth, etc. party defendant cannot be located within 30 calendar days from the grant of such leave. b. matters extraneous to the issue in the principal case are raised, or c. the effect would be to introduce a new and separate controversy into the action. Section 12. Bringing new parties. When the presence of parties other than those to the original action is required to the granting of complete relief in the determination of a counterclaim or cross-claim, the court shall order them to be brought in as defendants, if jurisdiction over them can be obtained. Section 13. Answer to third or fourth, etc. party complaint. A third, fourth, etc. party defendant may allege in his or her answer his or her defenses, counterclaims, or cross-claims, including such defenses that the third, fourth, etc. party plaintiff may have against the original plaintiff's claim. In proper cases, he or she may also assert a counterclaim against the original plaintiff in respect of the latter's claim against the third party plaintiff. Rule 7. Parts and contents of a pleading. Section 1. Caption. The caption sets forth the name of the court, the title of the action, and the docket number if assigned. The title of the action indicates the names of the parties. They shall all be named in the original complaint or petition, but in subsequent pleadings it shall be sufficient if the name of the first party on each side be stated with an appropriate indication when there are other parties. Their respective participation in the case shall be indicated. Section 2. The body. The body of the pleading sets forth its designation, the allegations of the parties' claims or defenses, the relief prayed for, and the date of the pleading. Letter A. Paragraphs. The allegations in the body of a pleading shall be divided into paragraphs so numbered to be readily identified, each of which shall contain a statement of a single set of circumstances so far as that can be done with convenience. A paragraph may be referred to by its number in all succeeding pleadings. Letter B. Headings. When two or more causes of action are joined, the statement of the first shall be prefaced by the words first cause of action, of the second by second cause of action, and so on for the others. When one or more paragraphs in the answer are addressed to one of several causes of action in the complaint, they shall be prefaced by the words answer to the first cause of action, or answer to the second cause of action, and so on. And when one or more paragraphs of the answer are addressed to several causes of action, they shall be prefaced by words to that effect. Letter C. Relief. The pleading shall specify the relief sought, but it may add a general prayer for such further or other reliefs as may be deemed just or equitable. D. Date. Every pleading shall be dated. Section 3. Signature and address. A. Every pleading and other written submissions to the court must be signed by the party or counsel representing him or her. Letter B. The signature of counsel constitutes a certificate by him or her that he or she has read the pleading and document, that to the best of his or her knowledge, information, and belief, formed after an inquiry reasonable under the circumstances. Number 1. It is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Number 2. The claims, defenses, and other legal contentions are warranted by existing law or jurisprudence, or by a non-frivolous argument for extending, modifying, or reversing existing jurisprudence. 3. The factual contentions have evidentiary support or, if specifically so identified, will likely have evidentiary support after availment of the modes of discovery under these rules. And 4. The denials of factual contentions are warranted on the evidence, or, if specifically so identified, are reasonably based on belief or a lack of information. Letter C. If the court determines, on motion or motu proprio, and after notice and hearing, that this rule has been violated, it may impose an appropriate sanction or refer such violation to the proper office for disciplinary action on any attorney, law firm, or party that violated the rule or is responsible for the violation. Absent exceptional circumstances, a law firm shall be held jointly and severally liable for a violation committed by its partner, associate, or employee. The sanction may include, but shall not be limited to, non-monetary directive or sanction, an order to pay a penalty in court, or, if imposed on motion and warranted for effective deterrence, an order directing payment to the movant of part or all of the reasonable attorney's fees and other expenses directly resulting from the violation, including attorney's fees for the filing of the motion for sanction. The lawyer or law firm cannot pass on the monetary penalty to the client. Section 4. Verification. Except when otherwise specifically required by law or rule, pleadings need not be under oath or verified. A pleading is verified by an affidavit of an affiant duly authorized to sign said verification. The authorization of the affiant to act on behalf of a party, whether in the form of a secretary's certificate or a special power of attorney, shall be attached to the pleading and shall allege the following attestations. A. The allegations in the pleading are true and correct based on his or her personal knowledge or based on authentic documents. B. The pleading is not filed to harass, cause unnecessary delay, or needlessly increase the cost of litigation. And C. The factual allegations therein have evidentiary support, or if specifically so identified, will likewise have evidentiary support after a reasonable opportunity for discovery. The signature of the affiant shall further serve as a certification of the truthfulness of the allegations in the pleading. A pleading required to be verified that contains a verification based on information and belief, or upon knowledge, information and belief, or lacks a proper verification shall be treated as an unsigned pleading. Section 5. Certification against form shopping. The plaintiff or principal party shall certify under oath in the complaint or other initiatory pleading asserting a claim for relief, or in a sworn certification annexed thereto and simultaneously filed therewith, A. That he or she has not therefore commenced any action or filed any claim involving the same issues in any court, tribunal, or quasi-judiciary agency, and to the best of his or her knowledge, no such other action or claim is pending therein. B. If there is such other pending action or claim, a complete statement of the present status thereof, and C. If he or she should thereafter learn that the same or similar action or claim has been filed or is pending, he or she shall report that fact within 5 calendar days therefrom to the court wherein his or her aforesaid complaint or initiatory pleading has been filed. The authorization of the affiant to act on behalf of the party, whether in the form of a secretary's certificate or a special power of attorney, should be attached to the pleading. Failure to comply with the foregoing requirements shall not be curable by mere amendment of the complaint or other initiatory pleading, but shall be cause for the dismissal of the case without prejudice unless otherwise provided, upon motion and after hearing. The submission of a false certification or non-compliance with any of the undertakings therein shall constitute indirect contempt of court, without prejudice to the corresponding administrative and criminal actions. If the acts of the party or his or her counsel clearly constitute willful and deliberate forum shopping, the same shall be ground for summary dismissal with prejudice and shall constitute direct contempt as well as a cause for administrative sanctions. Section 6. Contents. Every pleading stating a party's claim or defenses shall, in addition to those mandated by Section 2, Rule 7, state the following. Letter A. Names of witnesses who will be presented to prove a party's claim or defenses. B. Summary of the witnesses' intended testimonies, provided that the judicial affidavits of said witnesses shall be attached to the pleading and form an integral part thereof. Only witnesses whose judicial affidavits are attached to the pleading shall be presented by the parties during trial, except if a party presents meritorious reasons as basis for the admission of additional witnesses. No other witness or affidavit shall be heard or admitted by the court. And letter C. Documentary and object evidence in support of the allegations contained in the pleading. Rule 8. Manner of making allegations in pleadings. Section 1. In general, every pleading shall contain, in a methodical and logical form, a plain, concise, and direct statement of the ultimate facts, including the evidence on which the party pleading relies for his or her claim or defense, as the case may be. If a cause of action or defense relied on is based on law, the pertinent provisions thereof, and their applicability to him or her, shall be clearly and concisely stated. Section 2. Alternative causes of action or defenses. A party may set forth 2 or more statements of a claim or defense alternately or hypothetically, either in one cause of action or defense or in separate causes of action or defenses. When 2 or more statements are made in the alternative and one of them is made independently, would be sufficient. The pleading is not made insufficient by the insufficiency of one or more of the alternative statements. Section 3. Conditions precedent. In any pleading, a general averment of the performance or occurrence of all conditions precedent shall be sufficient. Section 4. Capacity. Facts showing the capacity of a party to sue or be sued, or the authority of a party to sue or be sued in a representative capacity, or the legal existence of an organized association of persons that is made a party, must be averred. A party desiring to raise an issue as to the legal existence of any party or the capacity of any party to sue or be sued in a representative capacity shall do so by special denial, which shall include such supporting particulars as are peculiarly within the pleader's knowledge. Section 5. Fraud, mistake, condition of the mind. In all averments of fraud or mistake, the circumstances constituting fraud or mistake must be stated with particularity. Malice, intent, knowledge, or other condition of the mind of a person may be averred generally. Section 6. Judgment. In pleading, a judgment or decision of a domestic or foreign court, judicial or quasi-judicial tribunal, or of a board or officer, it is sufficient to avert the judgment or decision without setting forth matter showing jurisdiction to render it. An authenticated copy of the judgment or decision shall be attached to the pleading. Section 7. Action or defense based on document. Whenever an action or defense is based upon a written instrument or document, the substance of such instrument or document shall be set forth in the pleading, and the original or a copy thereof shall be attached to the pleading as an exhibit, which shall be deemed to be part of the pleading. Section 8. How to contest such documents. When an action or defense is founded upon a written instrument or attached to the corresponding pleading as provided in the preceding section, the genuineness and due execution of the instrument shall be deemed admitted unless the adverse party, under oath, specifically denies them and sets forth what he or she claims to be the facts. But the requirements of an oath does not apply when the adverse party does not appear to be a party to the instrument, or when compliance with an order for an inspection of the original instrument is refused. Section 9. Official document or act. In pleading an official document or official act, it is sufficient to aver that the document was issued or the act was done in compliance with law. Section 10. Specific denial. A defendant must specify each material allegation of fact, the truth of which he or she does not admit, and whenever practicable, shall set forth the substance of the matters upon which he or she relies to support his or her denial. Where a defendant desires to deny only a part of an averment, he or she shall specify so much of it as is true and material, and shall deny only the remainder. Where a defendant is without knowledge or information sufficient to form a belief as to the truth of a material averment made to the complaint, he or she shall so state, and this shall have the effect of a denial. Section 11. Allegations not specifically denied deemed admitted. Material averments in a pleading asserting a claim or claims, other than those as to the amount of unliquidated damages, shall be deemed admitted when not specifically denied. Section 12. Affirmative Defenses. A. A defendant shall raise his or her affirmative defenses in his or her answer, which shall be limited to the reasons set forth under Section 5, letter B, Rule 6, and the following grounds. 1. That the court has no jurisdiction over the person of the defending party. Number 2, that venue is improperly laid. Number 3, that the plaintiff has no legal capacity to sue. Number 4, that the pleading asserting the claim states no cause of action. And number 5, that a condition precedent for filing the claim has not been complied with. Letter B. Failure to raise the affirmative defenses at the earliest opportunity shall constitute a waiver thereof. Letter C. The court shall motu proprio resolve the above affirmative defenses within 30 calendar days from the filing of the answer. D. As to the other affirmative defenses under the first paragraph of Section 5, letter B, Rule 6, the court may conduct a summary hearing within 15 calendar days from the filing of the answer. Such affirmative defenses shall be resolved by the court within 30 calendar days from the termination of the summary hearing. Letter E. Affirmative defenses, if denied, shall not be the subject of a motion for reconsideration or petition for certiorari, prohibition, or mandamus, but may be among the matters to be raised on appeal after a judgment on the merits. Section 13. Striking out of pleading or matter contained therein. upon motion made by a party before responding to a pleading, or, if no responsive pleading is permitted by these rules, upon motion made by a party within 20 calendar days after the service of the pleading upon him or her, or upon the court's own initiative at any time. The court may order any pleading to be stricken out, or that any sham or false, redundant, immaterial, impertinent, or scandalous matter be stricken out therefrom. Rule 9. Effect of failure to plead. Section 1. Defenses and objections not pleaded. Defenses and objections not pleaded, either in a motion to dismiss or in the answer, are deemed waived. However, when it appears from the pleadings or the evidence on record that the court has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, or that the action is barred by a prior judgment or by statute of limitations, the court shall dismiss the claim. Section 2. Compulsory counterclaim or cross-claim not set up, barred. A compulsory counterclaim or a cross-claim not set up shall be barred. Section 3. Default declaration of. If the defending party fails to answer within the time allowed, therefore, the court shall, upon motion of the claiming party, with notice to the defending party and proof of such failure, declare the defending party in default. Thereupon, the court shall proceed to render judgment granting the claimant such relief as his or her pleading may warrant, unless the court, in its discretion, requires the claimant to submit evidence. Such reception of evidence may be delegated to the clerk of court. Letter A. Effect of order of default. A party in default shall be entitled to notices of subsequent proceedings but shall not take part in the trial. Letter B. Relief from order of default. A party declared in default may at any time after notice thereof and before judgment file a motion under oath to set aside the order of default upon proper showing that his or her failure to answer was due to fraud, accident, mistake, or excusable negligence, and that he or she has a meritorious defense. In such case, the order of default may be set aside on such terms and conditions as the judge may impose in the interest of justice. Letter C. Effect of partial default. When a pleading asserting a claim states a common cause of action against several defending parties, some of whom answer and the others fail to do so, the court shall try the case against all upon the answers thus filed and render judgment upon the evidence presented. Letter D. Extent of relief to be awarded. A judgment rendered against a party in default shall neither exceed the amount nor be different in kind from that prayed for, nor award unliquidated damages. Letter E. Where no default allowed, if the defending party in an action for annulment or declaration of nullity of marriage or for legal separation fails to answer, the court shall order the Solicitor General or his or her deputized public prosecutor to investigate whether or not a collusion between the parties exists, and if there is no collusion, to intervene for the state in order to see, to wit, that the evidence submitted is not fabricated. Rule 10. Amended and Supplemental Pleadings. Section 1. Amendments in general. Pleadings may be amended by adding or striking out an allegation or the name of any party, or by correcting a mistake in the name of a party, or a mistaken or inadequate allegation or description in any other respect, so that the actual merits of the controversy may speedily be determined without regard to technicalities in the most expeditious and inexpensive manner. Section 2. Amendments as a matter of right. A party may amend his pleading once as a matter of right at any time before a responsive pleading is served, or, in the case of a reply, at any time within 10 calendar days after it is served. Section 3. Amendments by leave of court. Except as provided in the next preceding section, substantial amendments may be made only upon leave of court, but such leave shall be refused if it appears to the court that the motion was made with intent to delay or confer jurisdiction on the court. or the pleading stated no cause of action from the beginning which could be amended. Orders of the court upon the matters provided in this section shall be made upon motion filed in court and after notice to the adverse party and an opportunity to be heard. Section 4. Formal amendments. A defect in the designation of the parties and other clearly clerical or typographical errors may be summarily corrected by the court at any stage of the action, at its initiative or on motion, provided no prejudice is caused thereby to the adverse party. Section 5. No amendment necessary to conform to or authorize presentation of evidence. When issues not raised by the pleadings are tried with the express or implied consent of the parties, they shall be treated in all respects as if they had been raised in the pleadings. No amendment of such pleadings deemed amended is necessary to cause them to conform to the evidence. Section 6. Supplemental pleadings. Upon motion of a party, the court may, upon reasonable notice and upon such terms as are just, permit him or her to serve as supplemental pleading, setting forth transactions, occurrences, or events which have happened since the date of the pleading sought to be supplemented. The adverse party may plead thereto within 10 calendar days from notice of the order admitting the supplemental pleading. Section 7. Filing of amended pleadings. When any pleading is amended, a new copy of the entire pleading, incorporating the amendments, which shall be indicated by appropriate marks, shall be filed. Section 8. Effect of amended pleadings. An amended pleading supersedes the pleading that it amends. However, admissions in superseded pleadings may be offered in evidence against the pleader, and claims or defenses alleged therein not incorporated in the amended pleading shall be deemed waived. Rule 11. When to file responsive pleadings. Section 1. Answer to the complaint. The defendant shall file his or her answer to the complaint within 30 calendar days after service of summons, unless a different period is fixed by the court. Section 2. Answer of a defendant, foreign, private, juridical entity. Where the defendant is a foreign, private, juridical entity, and service of summons is made on the government official designated by law to receive the same, the answer shall be filed within 60 calendar days after receipt of summons by such entity. Section 3. Answer to amended complaint. When the plaintiff files an amended complaint as a matter of right, the defendant shall answer the same within 30 calendar days after being served with a copy thereof. Where its filing is not a matter of right, the defendant shall answer the amended complaint within 15 calendar days from notice of the order admitting the same. An answer earlier filed may serve as the answer to the amended complaint if no new answer is filed. This rule shall apply to the answer to an amended counterclaim, amended cross-claim, amended third, fourth, etc. party complaint, and amended complaint in intervention. Section 4. Answer to counterclaim or cross-claim. A counterclaim or cross-claim must be answered within 20 calendar days from service. Section 5. Answer to third, fourth, etc. party complaint. The time to answer a third or fourth, etc. party complaint shall be governed by the same rule as the answer to the complaint. Section 6. Reply. A reply, if allowed under Section 10, Rule 6 hereof, may be filed within 15 calendar days from service of the pleading responded to. Section 7. Answer to supplemental complaint. A supplemental complaint may be answered within 20 calendar days from notice of the order admitting the same, unless a different period is fixed by the court. The answer to the complaint shall serve as the answer to the supplemental complaint if no new or supplemental answer is filed. Section 8. Existing counterclaim or cross-claim. A compulsory counterclaim or a cross-claim that a defending party has at the time he or she files his or her answer shall be contained therein. Section 9. Counterclaim or cross-claim arising after answer. A counterclaim or cross-claim which either matured or was acquired by a party after serving his or her pleading may, with the permission of the court, be presented as a counterclaim or a cross-claim by supplemental pleading before judgment. Section 10. Omitted counterclaim or cross-claim. When a pleader fails to set up a counterclaim or a cross-claim through oversight, inadvertence, or excusable neglect, or when justice requires, he or she may, by leave of court, set up the counterclaim or cross-claim by amendment before judgment. Section 11. Extension of time to file an answer. A defendant may, for meritorious reasons, be granted an additional period of not more than 30 calendar days to file an answer. A defendant is only allowed to file one motion for extension of time to file an answer. A motion for extension to file any pleading other than an answer is prohibited and considered a mere scrap of paper. The court, however, may allow any other pleading to be filed after the time fixed by these rules. Rule 12. Bill of Particulars. Section 1. When applied for purpose. Before responding to a pleading, a party may move for a definite statement or for a bill of particulars of any matter which is not averred with sufficient definiteness or particularity to enable him or her properly to prepare his or her responsive pleading. If the pleading is a reply, the motion must be filed within 10 calendar days from service thereof. Such motion shall point out the defects complained of, the paragraph wherein they are contained, and the details desired. Section 2. Action by the court. Upon the filing of the motion, the clerk of court must immediately bring it to the attention of the court, which may either deny or grant it outright, or allow the parties the opportunity to be heard. Section 3. Compliance with order. If the motion is granted, either in whole or in part, the compliance therewith must be effected within 10 calendar days from notice of the order, unless a different period is fixed by the court. The bill of particulars, or a more definite statement ordered by the court, may be filed either in a separate or in an amended pleading, serving a copy thereof on the adverse party. Section 4. Effect of noncompliance. If the order is not obeyed, or in case of insufficient compliance therewith, the court may order the striking out of the pleading, or the portions thereof to which the order was directed, or make such other order as it deems just. Section 5. Stay of period to file responsive pleading. After service of the bill of particulars, or of a more definite pleading, or after notice of denial of his or her motion, the moving party may file his or her responsive pleading within the period to which he or she was entitled at the time of filing his or her motion, which shall not be less than 5 calendar days in any event. Section 6. Bill a part of pleading. A bill of particulars becomes part of the pleading for which it is intended. Rule 13. Filing and service of pleadings, judgments, and other papers. Section 1. Coverage. These rules shall govern the filing of all pleadings, motions, and other court submissions, as well as their service, except those for which a different mode of service is prescribed. Section 2. Filing and service defined. Filing is the act of submitting the pleading or other paper to the court. Service is the act of providing a party with a copy of the pleading or any other court submission. If a party has appeared by counsel, service upon such party shall be made upon his or her counsel, unless service upon the party and the party's counsel is ordered by the court. Where one counsel appears for several parties, such counsel shall only be entitled to one copy of any paper served by the opposite side. where several counsels appear for one party, such party shall be entitled to only one copy of any pleading or paper to be served upon the lead counsel if one is designated, or upon any one of them if there is no designation of a lead counsel. Section 3. Manner of filing. The filing of pleadings and other court submissions shall be made by a. Submitting personally the original thereof, plainly indicated as such, to the court. b. Sending them by registered mail. c. Sending them by accredited courier. Or d. Transmitting them by electronic mail or other electronic means as may be authorized by the court in places where the court is electronically equipped. In the first case, the clerk of court shall endorse on the pleading the date and hours of filing. In the second and third cases, the date of the mailing of motions, pleadings, and other court submissions and payments or deposits, as shown by the post office stamp on the envelope or the registry receipt, shall be considered as the date of their filing, payment, or deposit in court. The envelope shall be attached to the record of the case. In the fourth case, the date of electronic transmission shall be considered as the date of filing. Section 4. Papers required to be filed and served. Every judgment, resolution, order, pleading subsequent to the complaint, written motion, notice, appearance, demand, offer of judgment, or similar papers shall be filed with the court and served upon the parties affected. Section 5. Modes of service. Pleadings, motions, notices, orders, judgments, and other court submissions shall be served personally or by registered mail, accredited courier, electronic mail, facsimile transmission, other electronic means as may be authorized by the court, or as provided for in international conventions to which the Philippines is a party. Section 6. Personal service. Court submissions may be served by personal delivery of a copy to the party or to the party's counsel, or to their authorized representative named in the appropriate pleading or motion, or by leaving it in his or her office with his or her clerk, or with a person having charge thereof. If no person is found in his or her office, or his or her office is not known, or he or she has no office, then by leaving the copy between the hours of 8 in the morning and 6 in the evening at the party's or counsel's residence, if known, with a person of sufficient age and discretion residing therein. Section 7. Service by mail. Service by registered mail shall be made by depositing the copy in the post office in a sealed envelope, plainly addressed to the party or to the party's counsel at his or her office, if known, otherwise at his or her residence, if known, with postage fully prepaid, and with instructions to the postmaster to return the mail to the sender after 10 calendar days, if undelivered. If no registry service is available in the locality of either the sender or the addressee, service may be done by ordinary mail. Section 8. Substituted service. If the service of pleadings, motions, notices, resolutions, orders, and other papers cannot be made under the two preceding sections, the office and place of residence of the party or his or her counsel being unknown, service may be made by delivering the copy to the clerk of court, with proof of failure of both personal service and service by mail. The service is complete at the time of such delivery. Section 9. Service by electronic means and facsimile. Service by electronic means and facsimile shall be made if the party concerned consents to such modes of service. Service by electronic means shall be made by sending an email to the parties or counsel's electronic mail address, or through other electronic means of transmission as the parties may agree on, or upon direction of the court. Service by facsimile shall be made by sending a facsimile copy to the parties or counsel's given facsimile number. Section 10. Presumptive service. There shall be presumptive notice to a party of a court setting if such notice appears on the record to have been mailed at least 20 calendar days prior to the scheduled date of hearing, and if the addressee is from within the same judicial region of the court where the case is pending, or at least 30 calendar days if the addressee is from outside the judicial region. Section 11. Change of electronic mail address or facsimile number. A party who changes his or her electronic mail address or facsimile number while the action is pending must promptly file within 5 calendar days from such change a notice of change of email address or facsimile number with the court and serve the notice on all other parties. Service through the electronic mail address or facsimile number of a party shall be presumed valid unless such party notifies the court of any change, as aforementioned. Section 12. Electronic mail and facsimile subject and title of pleadings and other documents. The subject of the electronic mail and facsimile must follow the prescribed format. Case number, case title, and the pleading, order or document title. The title of each electronically filed or served pleading or other document, and each submission served by facsimile, shall contain sufficient information to enable the court to ascertain from the title: A. The party or parties filing or serving the paper. B. Nature of the paper. C. The party or parties against whom relief, if any, is sought. And D. The nature of the relief sought. Section 13. Service of judgments, final orders, or resolutions. Judgments, final orders, or resolutions shall be served either personally or by registered mail, upon ex parte motion of any party in the case. A copy of the judgment, final order, or resolution may be delivered by accredited courier at the expense of such party. When a party summoned by publication has failed to appear in the action, judgments, final orders, or resolutions against him or her shall be served upon him or her also by means of publication at the expense of the prevailing party. Section 14. Conventional service or filing of orders, pleadings, and other documents. Notwithstanding the foregoing, the following orders, pleadings, and other documents must be served or filed personally or by registered mail when allowed, and shall not be served or filed electronically unless express permission is granted by the court. A. Initiatory pleadings and initial responsive pleadings, such as an answer. B. Subpoena, protection orders, and writs. C. Appendices and exhibits to motions or other documents that are not readily amenable to electronic scanning may, at the option of the party filing such, be filed and served conventionally. And D. Sealed and confidential documents or records. Section 15. Completeness of service. Personal service is complete upon actual delivery. Service by ordinary mail is complete upon the expiration of 10 calendar days after mailing, unless the court otherwise provides. Service by registered mail is complete upon actual receipt by the addressee or after 5 calendar days from the date he or she received the first notice of the postmaster, whichever date is earlier. Service by accredited courier is complete upon actual receipt by the addressee or after at least 2 attempts to deliver by the courier service or upon the expiration of 5 calendar days after the first attempt to deliver, whichever is earlier. Electronic service is complete at the time of the electronic transmission of the document, or when available at the time that the electronic notification of service of the document is sent. Electronic service is not effective or complete if the party serving the document learns that it did not reach the addressee or person to be served. Service by facsimile transmission is complete upon receipt by the other party as indicated in the facsimile transmission printout. Section 16. Proof of filing. The filing of a pleading or any other court submission shall be proved by its existence in the record of the case. A. If the pleading or any other court submission is not in the record, but is claimed to have been filed personally, the filing shall be proven by the written or stamped acknowledgement of its filing by the clerk of court on a copy of the pleading or court submission. B. If the pleading or any other court submission was filed by registered mail, the filing shall be proven by the registry receipt and by the affidavit of the person who mailed it, containing a full statement of the date and place of deposit of the mail in the post office in a sealed envelope addressed to the court, with postage fully prepaid, and with instructions to the postmaster to return the mail to the sender after 10 calendar days, if not delivered. C. If the pleading or any other court submission was filed through an accredited courier service, the filing shall be proven by an affidavit of service of the person who brought the pleading or other document to the service provider, together with the courier's official receipt and document tracking number. D. If the pleading or any other court submission was filed by electronic mail, the same shall be proven by an affidavit of electronic filing of the filing party, accompanied by a paper copy of the pleading or other document transmitted, or a written or stamped acknowledgment of its filing by the clerk of court. If the paper copy sent by electronic mail was filed by registered mail, paragraph B of this section applies. Letter E. If the pleading or any other court submission was filed through other authorized electronic means, the same shall be proven by an affidavit of electronic filing of the filing party, accompanied by a copy of the electronic acknowledgment of its filing by the court. Section 17. Proof of service. Proof of personal service shall consist of a written admission of the party served, or the official return of the server, or the affidavit of the party serving, containing a statement of the date, place, and manner of service if the service is made by a ordinary mail. Proof shall consist of an affidavit of the person mailing, stating the facts showing compliance with Section 7 of this rule. B. Registered mail. Proof shall be made by the affidavit mentioned above and the registry receipt issued by the mailing office. The registry return card shall be filed immediately upon its receipt by the sender, or in lieu thereof, the unclaimed letter together with a certified or sworn copy of the notice given by the postmaster to the addressee. Letter C. Accredited courier service. Proof shall be made by an affidavit of service executed by the person who brought the pleading or paper to the service provider, together with the courier's official receipt or document tracking number. Letter D. Electronic mail, facsimile, or other authorized electronic means of transmission. Proof shall be made by an affidavit of service executed by the person who sent the email, facsimile, or other electronic transmission, together with a printed proof of transmittal. Section 18. Court-issued orders and other documents. The court may electronically serve orders and other documents to all the parties in the case, which shall have the same effect and validity as provided herein. A paper copy of the order or other document electronically served shall be retained and attached to the record of the case. Section 19. Notice of lis pendens. In an action affecting the title or the right of possession of real property, the plaintiff and the defendant, when affirmative relief is claimed in his or her answer, may record in the office of the Registry of Deeds of the province in which the property is situated a notice of the pendency of the action. Said notice shall contain the names of the parties and the object of the action or defense, and a description of the property in that province affected thereby. Only from the time of filing such notice for record shall a purchaser or encumbrancer of the property affected thereby be deemed to have constructive notice of the pendency of the action, and only if its pendency against the parties designated by their real names. The notice of lis pendens herein above mentioned may be cancelled only upon order of the court, after proper showing that the notice is for the purpose of molesting the adverse party, or that it is not necessary to protect the rights of the party who caused it to be recorded. Rule 14. Summons. Section 1. Clerk to issue summons. Unless the complaint is on its face dismissible under Section 1, Rule 9, The court shall, within 5 calendar days from receipt of the initiatory pleading and proof of payment of the requisite legal fees, direct the clerk of court to issue the corresponding summons to the defendant. Section 2. Contents. The summons shall be directed to the defendant, signed by the clerk of court under seal, and contain a. The name of the court and the names of the parties to the action. Letter B. When authorized by the court upon ex parte motion, an authorization for the plaintiff to serve summons to the defendant. C. A direction that the defendant answer within the time fixed by these rules, and D. A notice that unless the defendant so answers, plaintiff will take judgment by default and may be granted the relief applied for. A copy of the complaint and order for appointment of guardian ad litem, if any, shall be attached to the original and each copy of the summons. Section 3. By whom served. The summons may be served by the sheriff, his or her deputy, or other proper court officer, and in case of failure of service of summons by them, the court may authorize the plaintiff to serve the summons together with the sheriff. In cases where summons is to be served outside the judicial region of the court where the case is pending, the plaintiff shall be authorized to cause the service of summons. If the plaintiff is a juridical entity, it shall notify the court in writing and name its authorized representative therein, attaching a board resolution or secretary's certificate thereto, as the case may be, stating that such representative is duly authorized to serve the summons on behalf of the plaintiff. If the plaintiff misrepresents that the defendant was served summons, and it is later proved that no summons was served, the case shall be dismissed with prejudice. The proceeding shall be nullified, and the plaintiff shall be meted appropriate sanctions. If summons is returned without being served on any or all the defendants, the court shall order the plaintiff to cause the service of summons by other means available under the rules. Failure to comply with the order shall cause the dismissal of the initiatory pleading without prejudice. Section 4. Validity of summons and issuance of alias summons. Summons shall remain valid until duly served, unless it is recalled by the court. In case of loss or destruction of summons, the court may, upon motion, issue an alias summons. There is failure of service after unsuccessful attempts to personally serve the summons on the defendant in his or her address indicated in the complaint. Substituted service should be in the manner provided under Section 6 of this rule. Section 5. Service in person on defendant. Whenever practicable, the summons shall be served by handing a copy thereof to the defendant in person and informing the defendant that he or she is being served. Or, if he or she refuses to receive and sign for it, by leaving the summons within the view and in the presence of the defendant. Section 6. Substituted service. If for justifiable causes the defendant cannot be served personally after at least 3 attempts on 2 different dates, service may be effected. A. By leaving copies of the summons at the defendant's residence to a person at least 18 years of age and of sufficient discretion residing therein. B. By leaving copies of the summons at the defendant's office or regular place of business with some competent person in charge thereof. A competent person includes, but is not limited to, 1 who customarily receives correspondences for the defendant. C. By leaving copies of the summons if refused entry upon making his or her authority and purpose known with any of the officers of the Homeowners Association or Condominium Corporation, or its chief security officer in charge of the community or the building where the defendant may be found. And D. By sending an electronic mail to the defendant's electronic mail address, if allowed by the court. Section 7. Service of an entity without juridical personality. When persons associated in an entity without juridical personality are sued under the name by which they are generally or commonly known, service may be effected upon all the defendants by serving upon any one of them, or upon the person in charge of the office or place of business maintained in such name, but such service shall not find individually any person whose connection with the entity has, upon due notice, been severed before the action was filed. Section 8. Service upon prisoners. When the defendant is a prisoner confined in a jail or institution, service shall be effected upon him or her by the officer having the management of such jail or institution who is deemed as a special sheriff for said purpose. The jail warden shall file a return within 5 calendar days from service of summons to the defendant. Section 9. Service consistent with international conventions. Service may be made through methods which are consistent with established international conventions to which the Philippines is a party. Section 10. Service upon minors and incompetent. When the defendant is a minor, insane, or otherwise an incompetent person, service of summons shall be made upon him or her personally and on his or her legal guardian if he or she has one, or if none, upon his or her guardian ad litem, whose appointment shall be applied for by the plaintiff. In the case of a minor, service shall be made on his or her parent or guardian. Section 11. Service upon spouses. When spouses are sued jointly, service of summons should be made to each spouse individually. Section 12. Service upon domestic private juridical entity. When the defendant is a corporation, partnership, or association organized under the laws of the Philippines with a juridical personality, service may be made on the president, managing partner, general manager, corporate secretary, treasurer, or in-house counsel of the corporation, wherever they may be found, or in their absence or unavailability, on their secretaries. If such service cannot be made upon any of the foregoing persons, it shall be made upon the person who customarily receives the correspondence for the defendant at its principal office. In case the domestic juridical entity is under receivership or liquidation, service of summons shall be made on the receiver or liquidator, as the case may be. Should there be a refusal on the part of the persons above mentioned to receive summons despite at least 3 attempts on 2 different dates, service may be made electronically, if allowed by the court, as provided under Section 6 of this rule. Section 13. Duty of counsel of record. Where the summons is improperly served and a lawyer makes a special appearance on behalf of the defendant to, among others, question the validity of service of summons, the counsel shall be deputized by the court to serve summons on his or her client. Section 14. Service upon foreign private juridical entities. When the defendant is a foreign private juridical entity which has transacted or is doing business in the Philippines as defined by law, service may be made on his resident agent designated in accordance with law for that purpose, or, if there be no such agent, on the government official designated by law to that effect, or on any of its officers, agents, directors, or trustees within the Philippines. If the foreign private juridical entity is not registered in the Philippines, or has no resident agent, but has transacted or is doing business in it, as defined by law, such service may, with leave of court, be effected outside the Philippines through any of the following means. A. By personal service, course, through the appropriate court in the foreign country with the assistance of the Department of Foreign Affairs. B. By publication once in a newspaper of general circulation in the country where the defendant may be found, and by serving a copy of the summons and the court order by registered mail at the last known address of the defendant. C. By facsimile. D. By electronic means with the prescribed proof of service, or E. By such other means as the court, in its discretion, may direct. Section 15. Service upon public corporations. When the defendant is the Republic of the Philippines, service may be effected on the Solicitor General. In case of a province, city, or municipality, or like public corporations, service may be effected on its executive head, or on such other officer or officers as the law or the court may direct. Section 16. Service upon defendant whose identity or whereabouts are unknown. In any action where the defendant is designated as an unknown owner, or the like, or whenever his or her whereabouts are unknown and cannot be ascertained, by diligent inquiry within 90 calendar days from the commencement of the action, service may, by leave of court, be effected upon him or her, by publication in a newspaper of general circulation, and in such places and for such time as the court may order. Any order granting such leave shall specify a reasonable time, which shall not be less than 60 calendar days after notice, within which the defendant must answer. Section 17. Extra territorial service. When the defendant does not reside and is not found in the Philippines, and the action affects the personal status of the plaintiff, or relates to, or the subject of which is property within the Philippines, in which the defendant has or claims a lien or interest, actual or contingent, or in which the relief demanded consists, wholly or in part, in excluding the defendant from any interest therein, or the property of the defendant has been attached within the Philippines, service may, by leave of court, be effected out of the Philippines by personal service as under Section 6, or as provided for in international conventions to which the Philippines is a party, or by publication in a newspaper of general circulation in such places and for such time as the court may order, in which case a copy of the summons and order of the court shall be sent by registered mail to the last known address of the defendant, or in any other manner the court may deem sufficient. Any order granting such leave shall specify a reasonable time, which shall not be less than 60 calendar days after notice, within which the defendant must answer. Section 18. Residence temporarily out of the Philippines. When any action is commenced against a defendant who ordinarily resides within the Philippines, but who is temporarily out of it, service may, by leave of court, be also effected out of the Philippines, as under the preceding section. Section 19. Leave of court. Any application to the court under this rule for leave to effect service in any manner for which leave of court is necessary shall be made by motion in writing, supported by affidavit of the plaintiff or some person on his behalf, setting forth the grounds for the application. Section 20. Return. Within 30 calendar days from issuance of summons by the clerk of court and receipt thereof, the sheriff or process server or person authorized by the court shall complete its service. Within 5 calendar days from service of summons, the server shall file with the court and serve a copy of the return of the plaintiff's counsel, personally, by registered mail, or by electronic means authorized by the rules. Should substituted service have been effected, the return shall state the following. 1. The impossibility of prompt personal service within a period of 30 calendar days from issue and receipt of summons. 2. The date and time of the 3 attempts of at least 2 different dates to cause personal service and the details of the inquiries made to locate the defendant residing thereat. And 3. The name of the person at least 18 years of age and of sufficient discretion residing thereat, name of competent person in charge of the defendant's office or regular place of business, or name of the officer of the Home Owners Association or Condominium Corporation, or its chief security officer in charge of the community or building where the defendant may be found. Section 21. Proof of service. The proof of service of a summons shall be made in writing by the server and shall set forth the manner, place, and date of service, shall specify any papers which have been served with the process in the name of the person who received the same, and shall be sworn to when made by a person other than a sheriff or his or her deputy. If summons were served by electronic mail, a printout of said email, with the copy of the summons as served and the affidavit of the person mailing, shall constitute as proof of service. Section 22. Proof of service by publication. If the service has been made by publication, Service may be proved by the affidavit of the publisher, editor, business or advertising manager, to which affidavit a copy of the publication shall be attached, and by an affidavit showing the deposit of a copy of the summons and order for publication in the post office, postage prepaid directed to the defendant by registered mail to his or her last known address. Section 23. Voluntary appearance. The defendant's voluntary appearance in the action shall be equivalent to service of summons. The inclusion in a motion to dismiss or other grounds aside from lack of jurisdiction over the person of the defendant shall be deemed a voluntary appearance. Rule 15. Motions. Section 1. Motion defined. A motion is an application for relief other than by a pleading. Section 2. Motions must be in writing. All motions shall be in writing except those made in open court or in the course of a hearing or trial. A motion made in open court or in the course of a hearing or trial should immediately be resolved in open court after the adverse party is given the opportunity to argue his or her position thereto. When a motion is based on facts not appearing on record, the court may hear the matter on affidavits or depositions presented by the respective parties, but the court may direct that the matter be heard wholly or partly on oral testimony or depositions. Section 3. Contents. A motion shall state the relief sought to be obtained and the grounds upon which it is based, and if required by these rules or necessary to prove facts alleged therein, shall be accompanied by supporting affidavits and other papers. Section 4. Hearing of motion is deleted, replaced by Section 4. Non-litigious motions. Motions which the court may act upon without prejudicing the rights of adverse parties are non-litigious motions. These motions include a. Motion for the issuance of an alias summons. b. Motion for extension to file answer. c. Motion for postponement. d. Motion for the issuance of a writ of execution. e. Motion for the issuance of an alias writ of execution. f. Motion for the issuance of a writ of possession. g. Motion for the issuance of an order directing the sheriff to execute the final certificate of sale. And h. Other similar motions. These motions shall not be set for hearing and shall be resolved by the court within 5 calendar days from receipt thereof. Section 5. Litigious motions. Litigious motions include 1. Motion for bill of particulars. 2. Motion to dismiss. 3. Motion for new trial. 4. Motion for reconsideration. 5. Motion for execution pending appeal. 6. Motion to amend after responsive pleading has been filed. 7. Motion to cancel statutory lien. 8. Motion for an order to break in or for a writ of demolition. 9. Motion for intervention. 10. Motion for judgment on the pleadings. 11. Motion for summary judgment. 12. Demurrer to evidence. 13. Motion to declare defendant in default. And 14. Other similar motions. b. All motions shall be served by personal service, accredited private courier, or registered mail, or electronic means, as to ensure their receipt by the other party. Letter C. The opposing party shall file his or her opposition to a litigious motion within 5 calendar days from receipt thereof. No other submissions shall be considered by the court in the resolution of the motion. The motion shall be resolved by the court within 15 calendar days from its receipt of the opposition thereto, or upon expiration of the period to file such opposition. Section 6. Notice of hearing on litigious motions. Discretionary. The court may, in the exercise of its discretion, and if deemed necessary for its resolution, call a hearing on the motion. The notice of hearing shall be addressed to all parties concerned and shall specify the time and date of the hearing. Section 7. Proof of service necessary. No written motion shall be acted upon by the court without proof of service thereof, pursuant to Section 5, letter B hereof. Section 8. Motion day. Except for motions requiring immediate action, where the court decides to conduct hearing on a litigious motion, the same shall be set on a Friday. Section 9. Omnibus Motion. Subject to the provisions of Section 1 of Rule 9, a motion attacking a pleading, order, judgment, or proceeding shall include all objections then available, and all objections not so included shall be deemed waived. Section 10. Motion for leave. A motion for leave to file a pleading or motion shall be accompanied by the pleading or motion sought to be admitted. Section 11. Form. The rules applicable to pleadings shall apply to written motions so far as concerns caption, designation, signature, and other matters of form. Section 12. Prohibited motions. The following motions shall not be allowed. A. Motion to dismiss except in the following grounds. 1. That the court has no jurisdiction over the subject matter of the claim. 2. That there is another action pending between the same parties for the same cause. And 3. That the cause of action is barred by a prior judgment or by the statute of limitations. Letter B. Motion to hear affirmative defenses. Letter C. Motion for reconsideration of the court's action on the affirmative defenses. Letter D. Motion to suspend proceedings without a temporary restraining order or injunction issued by a higher court. Letter E. Motion for execution of time to file pleadings, affidavits, or any other papers, except a motion for extension to file an answer as provided by Section 11, Rule 11, and F. Motion for postponement, intended for delay, except if it is based on acts of God, force majeure, or physical inability of the witness to appear and testify. If the motion is granted based on such exceptions, the moving party shall be warned that the presentation of its evidence must still be terminated on the dates previously agreed upon. A motion for postponement, whether written or oral, shall at all times be accompanied by the original official receipt from the office of the clerk of court, evidencing payment of the postponement fee under Section 21, Letter B, Rule 141, to be submitted either at the time of the filing of said motion or not later than the next hearing date. The clerk of court shall not accept the motion unless accompanied by the original receipt. Section 13. Dismissal with prejudice. Subject to the right of appeal, an order granting a motion to dismiss or an affirmative defense that the cause of action is barred by a prior judgment or by the statute of limitations, that the claim or demand set forth in the plaintiff's pleading has been paid, waived, abandoned, or otherwise extinguished, or that the claim on which the action is founded is unenforceable under the provisions of the statute of frauds, shall bar the free filing of the same action or claim.